AI makes it easier to get a likelihood of confusion, right? Because, um, for example, in the New Hampshire primary, somebody uh, put together a robocall from ostensibly from Joe Biden saying, please don't vote, um, trying to suppress the vote. And that was a clear attempt at a fraud. There wasn't any disclaimer, and somebody might reasonably have been fooled. Um, don't vote in the primary, and that had the effect of suppressing the vote, and at which point it becomes a criminal offense. But the fact that they used AI, I don't think uh, is what makes that illegal. It's the intent to defraud, and it would have been just as intentional if instead of using AI, they hired Dana Carvey to do a Joe Biden impersonation.
Hello, ColemanNators. Thank you once again for joining us on the program. Today, we're going to catch up with an old friend and an old pro bono client. I don't even remember what the case was, but I think we won. I know that. I represented you and Walter Olson. It was some kind of slap suit in New Jersey. This is Ted Frank. This is the fascinating Ted Frank, who is now director of litigation and senior attorney at the Hamilton Lincoln Law Institute, who does all kinds of interesting work that we're going to talk about, and that a lot of the people who listen to this are going to like, because besides the good old First Amendment and liberty-oriented activism that he's doing now with the Hamilton Lincoln Law Institute, Ted and I have worked a little bit together, but mostly Ted has managed to get on without me, in connection with his fascinating practice of trying to actually get people who are members of class in class action lawsuits to get some little bit of benefit in addition to their attorneys getting benefit. And a lot, Ted doesn't get, I think, quite the attention that he ought to for that, but who among us really does? But Ted, great to have you on. Thanks.
Great to be here, Ron. Great to see you again.
I'm glad also, when we had Ted scheduled a couple of weeks ago, and then he had the audacity to come up with some medical excuse and find himself in the hospital for a while. But here he is, hale and hearty, robust as ever. And Ted and I hooked up again, in particular, in connection with the Hamilton Lincoln Law Firm Institute thingy lawsuit on behalf of Christopher Coles, a case that I really was hoping maybe I would be filing. But no, Ted was ready with this mother. The second that law was passed. So everyone remembers what this is about. The Mr. Reagan or the Coles versus, let me pull something up that looks
Bonta.
Coles versus Bonta.
AG Bonta.
Yeah. And who among us has not sued Bonta at one time or another?
We're 3 for 3.
So here is my favorite author, Jane Coleman, reporting on the story of that smirking wise ass signing into law the controversial ban on political deep fake, or as Kamala calls them, cheap fake. No, it wasn't Kamala. It was the press secretary lady. Do you know that she's the first African-American lesbian press secretary lady ever? Did you know that?
Who?
I bet you didn't know. It looks like you didn't know that. So this, all right, folks. So
your Democrat candidate for president, because Joe Biden finally exposed his senility in his debate. I was selected because I am the ultimate diversity hire. I'm both a woman and a person of color. So if you criticize anything I say, you're both sexist and racist. I may not know the first thing about running the country, but remember, that's a good thing if you're a deep state puppet. I had 4 years under the tutelage of the ultimate deep state puppet, a wonderful mentor, Joe Biden. Joe taught me rule number one, carefully hide your total income. I take insignificant things and I discuss them as if they're significant. And I believe that exploring the significance of the insignificant is in itself significant.
Talking about the significance of the passage of time, right? The significance of the passage of time. There is great significance to the passage of time, and there.
I'm sure we all agree that this should be illegal. So, obviously this was, so Gavin Newsom had a cow. And
so, right, the video came out. Elon Musk retweeted it. And that combination of criticism of the vice president and it coming from Elon Musk got Gavin Newsom very mad. And he demanded that a law be made to make it illegal. And we saw that. And as you might know, in First Amendment cases, one of the trickier parts is establishing standing.
Yeah.
The power to sue. And just saying, hey, there's a law here that potentially infringes my First Amendment rights isn't necessarily enough to get standing and be allowed to bring a federal suit. You have to show a credible threat. So the very fact that we had a governor threatening this guy with a ban, that's about as credible a threat as you can get. So
the harm
we saw that,
and the threat, easy. Those were layups.
Those were layups. The law would have been clearly illegal because this was protected speech. It's political commentary. It's parody. It's satire. And the fact that it's using AI rather than a voice imitator or a Rich Little, a professional impersonation person, doesn't make it any less illegal. Technology doesn't magically take something outside the realm of the First Amendment. So we recognized that there is this potential lawsuit here, and we got a hold of Mr. Reagan and we said, hey, the governor's going to come after you here. And we'd be happy to represent you pro bono if you don't already have attorneys. And
you stepped on your own payoff, which was that, okay, we've got the harm, we've got the threat, but what do we do about standing? Because everybody wants to file this lawsuit. How do we get to file this lawsuit? How do we get to find the plaintiff who can absolutely walk into court and say, I'm going to be harmed?
And it's easy when you have the governor saying, I'm hereby banning your video. All right. They're threatening
a guy who's the you get Mr. Reagan.
Yeah, exactly. And that
Christopher Cole.
Right away, it's a threshold, and the government can't even begin to challenge that. You have the governor saying, I passed this law to make this illegal.
Ted, wouldn't you say at this point that states and municipalities are passing laws that they know, everyone in the room knows are unconstitutional just for political signaling? It's got to be, right? I mean, could anyone who walked anywhere near a law school possibly think this law could have been constitutional?
I have no idea why they thought this. And the original draft of the law had an exception for parody. And they took that exception out, at which point there's no way that it's constitutional. And they thought, oh, well, there's just a disclosure requirement. But you look at the disclosure requirement, and we have this in our complaints. We do a mock-up of the video consistent with the disclosure requirements, and it requires gigantic text throughout the length of the video, and it blocks the entire video.
There it is.
Paragraph 87. Yeah, exactly.
And that's really, you guys weren't budging at all there. That's really what it would have had to look like?
That's what it would have had to look like under the statute's safe harbor. There was no other safe harbor. It's not enough to say this is parody. You have to use the precise language California demands at the precise font size that California demands. and it wouldn't even fit on the video screen.
You know, Ted, though, it's funny you mentioned Rich Little, which people of a certain age only are going to understand the illusion. He was a great mimic of celebrity
I could have gone
voices
even older and said Von Meter, right? But
back in the day. But
Von Meter won the Grammy for Best Album. Yeah, sorry, my internet connection's unstable here.
so I made a little video after you grabbed the headline on this, explaining what I thought might have been the premise, because the fact is you can't under trademark law, and as well as under California's very strong right of publicity law, you cannot use a voice imitator, a mimic, to mimic the voice of a celebrity or a celebrity singer or someone who has a very familiar voice like Bette Midler or Tom Waits. These are people also from that people of a certain age are going to recognize the names. But as companies that tried to do so found out, if you try to give the impression that a celebrity has endorsed or is signed on to perform for your commercial, you don't get to do that because you're basically saying I couldn't.
That's basic fraud.
So the thinking might have been, well, here people are going to think that Kamala Harris actually described herself as a fraud and a DEI candidate, and that's where the analogy falls apart. These are obvious parodies, but you think that it would have been helpful? It would have been a little bit harder for you if they
if they had added there's a requirement for intent to defraud. I think that's a different statute, but then it doesn't reach parody. This guy labeled the video parody. He wasn't trying to defraud anybody, and any reasonable person would have said, "This is satire. This is parody." Then we know this isn't Kamala Harris. It sounds like Kamala Harris. It's a funny parody. And in fact, Alabama has a similar statute, but it not quite as broad as California's. When we sued California, Governor Newsom whined, well, why didn't they sue Alabama? And I'm like, well, for one thing, the governor of Alabama didn't threaten our client. But, just to be safe, we wrote to the Alabama Attorney General. We said, you have the statute out there. We just want to make sure you're not going to use it to go after our client. And the Alabama Attorney General quite reasonably said, of course not. This is parody. This is protected First Amendment speech. There's no reasonable person would think this is an attempt at a fraud.
You think all things being equal so that satisfied you guys?
That satisfied us, right? They told us they weren't going to prosecute. The AG came out with such strong language that if any other state official, county official tries to prosecute, we have Exhibit 1 in the motion to dismiss.
And this is great. This language exactly tracks what we were just talking about. This is from the response from the Alabama AG, that the act does not apply unless a reasonable viewer or listener would incorrectly believe that the depicted individual engaged in the speech or conduct depicted. There has to be what in trademark law, and it's analogous, obviously, would be a likelihood of confusion. There has to be deception.
Right.
So then we would agree that probably there is something different about AI.
Well, I think I think AI is a matter of kind, not a matter of type, right? AI makes it easier to get a likelihood of confusion, right? Because, for example, in the New Hampshire primary, somebody put together a robocall ostensibly from Joe Biden saying, please don't vote, trying to suppress the vote. And that was a clear attempt at a fraud. There wasn't any disclaimer, and somebody might reasonably have been fooled. Don't vote in the primary. And that had the effect of suppressing the vote, and at which point it becomes a criminal offense. But the fact that they used AI, I don't think is what makes that illegal. It's the intent to defraud, and it would have been just as intentional if instead of using AI, they hired Dana Carvey to do a Joe Biden impersonation.
Now you did sue Minnesota.
Yes, Minnesota has a similar statute, and we have a governor of Minnesota that says, disinformation isn't free speech or protected by the First Amendment, and we think we have a strong case in Minnesota too.
I would think so. I would very much think so. So that's exciting. No, when did you start Hamilton Lincoln Law Institute?
So Melissa Holyoke, who's now a commissioner at the Federal Trade Commission, and I, we were at the Competitive Enterprise Institute, and we decided we wanted to do something bigger in scope than what we could really do within the CEI framework. And we started up our own nonprofit public interest law firm, which is now up to 7 attorneys. So that was in 2018, 2019.
Oh, okay. And you folded the Class Action Fairness Center.
We're still doing the class action. We started as the Center for Class Action Fairness in 2009. Went through several iterations of that, merged with CEI in 2015, and then spun things back out in 2019. We did this because we wanted to do more than just class actions. We wanted to do the First Amendment stuff. We wanted to take on right-wing causes that nobody else was doing, like regulatory extortion, like we're very excited about the lawsuit we brought in Chicago against pro-Hamas protesters who blocked the road illegally. And, these are things we could not have done at CEI, but we have the capacity to do at HLLI. But meanwhile, we're still doing our class action stuff where we win millions of dollars for shareholders and consumers by attacking unfair abuses of the class action settlement system.
Do you get a fair shake from judges in these class action cases? Sometimes it looks like they just thrust you aside. They just don't want to hear.
It varies from court to court. I think we get more respect from appellate courts than from district courts. I think that's just a natural, the district court is usually dealing with, is not familiar with the class action system and just sees, I have this complicated case on my docket. These people are offering to settle it, and these officious intermeddlers who I've never heard of before have just made an appearance and are telling me I have to do a lot of extra work. That's not always a popular position.
Why don't you explain a little about one of the things I'm looking here at the Lundy case, an excellent example. It's not just that the lawyers get a bunch of money, it's that a bunch of other money flows to people who've got nothing to do with the lawsuit, and it turns out to be a major source of funding for the left.
That's one aspect of the class action settlement abuse, but in general, the problem in the class action system is just basic conflicts of interest. The defendant wants to get out of a case as cheaply as possible. The plaintiff's attorneys are representing the class, but they're also representing their own pocketbooks. And every dollar that goes to the class is a dollar that doesn't go to the attorneys. And it gives everybody involved the incentive to structure a settlement to freeze out the class members. So that can be either a double dipping, like you mentioned, with what the doctrine is called cypre. Instead of giving money to the class, you give money to the friends of the plaintiff's lawyers, and then call that a class benefits. So we have a case pending in the Ninth Circuit against Google, It's a $63 million settlement, but the class is getting zero. The lawyers are getting 19 million, and 44 million are going to left-wing groups that are, many of which are affiliated with the plaintiffs' lawyers. So the plaintiffs' lawyers are getting paid twice, basically. Left-wing causes are getting funded at the expense of, of a politically diverse class that probably would not want to support these things. And the lawyers are getting paid, but meanwhile the class gets nothing and would be worse off than if there wasn't a settlement at all. So there are settlements like that, and then there were other settlements where the attorneys just sort of create the illusion of relief. They say, "Oh, we've made $20 million available. Oh, what a coincidence! Only $1 million was claimed, but we're entitled to $7 million because we made $20 million available, even though everybody knew that there was no way the defendant was going to pay $20 million to the class." So in one of our biggest Ninth Circuit wins in the last few years, Bresenio versus Conagra Foods, it was literally $7 million for the attorneys and $1 million for the class.
That is nauseating. Why is it? So it seems that there is a real opportunity here for a legislative fix, at least with the Cypre third-party stuff. I mean, that is
I would
nuts.
say that the law is already there, and we just require the courts to enforce it. The law already says, Rule 22, E2, C2, that courts should only approve a settlement based on the effectiveness of the means of distribution to the class, of the methodology of distribution to the class. And you can't think of a less effective method of distributing money to the class than giving it to people who aren't in the class instead of giving it to the class. Courts have gotten this right. Some courts have gotten this wrong. There's a circuit split. Eventually we'll get to take this to the Supreme Court and they'll resolve it.
I'm looking here, browsing. It's really, I don't know why it took so long for me to, I'm always looking for ways to distract myself from work. The broiler chicken case.
This was a fun case. This was a very large attorney fee request that the district court rubber stamped. We took it to the Seventh Circuit, and the Seventh Circuit agreed with us that that the court failed to consider evidence that the fee request was above market. On remand, the court did reduce the fees $5 to $6 million. So that's $5 to $6 million more going to the class. So that's great. We think that the court still got it wrong in terms of what they were instructed to do by the Seventh Circuit. So we're up on appeal again. We'll be filing something next week in the Seventh Circuit.
Wild. It is. I mean, I've done a little bit of class action work besides a couple of cases that I just rode shotgun with you, representing defendants. And I saw what a game it is. I saw what the game is and how it's a game that both sides play.
Yeah.
And people become very, very wealthy on these cases. So obviously I've only done a few of them.
On both sides, I clearly picked the wrong thing to do.
Right. But we may as well make them pay.
Yeah, well, I thought by now I would have been bought off and had a real job, but I get to keep doing this.
Don't you love when people call you a shill on the internet?
I don't know who I'm a shill for. The chamber, the National Association of Manufacturers filed a brief against, we have a settlement where the attorneys got 2 or 3 times as much as what the class got. We took it up to appeal in the Second Circuit, and the National Association for Manufacturers, who I'm supposedly a shill for, filed an amicus brief saying, no, approve the settlement. These defendants are begging to be ripped off at the expense of consumers, begging to pay attorneys money to sue them.
So what was that about?
I don't understand it at all.
You don't understand it. You didn't figure out the game there.
I can see why in an individual case it's a collective action problem. Kimberly Clark would be happy with if everybody had to adhere to the rule, but they don't want to be singled out by me. So they want their settlement approved, but maybe in a future case, go do it. But that's the underlying problem. The chamber has given us no support at all.
People are always, there's so much suspicion about lawyers, and that's why I like that when I have the opportunity to talk about someone like you who's doing things that are rather idealistic. Yes, you do make a living from it. You're allowed to make a living, but as we both pointed out, we could make much better livings, especially someone like you who understands the playing field very well, being on the other side. It's important for people to know just how many public spirited folks there are in the profession.
Yeah, it's absolutely the case that and it's why we're the only ones doing what we do. It's just, even in terms of doing objections, there are just easier ways to make money. So
Hamilton Lincoln, there are so many guys working, so many nonprofits, so many public interest law firms working this territory. Okay, I give you all the credit in the world. You got in there for the easy win. I'm not going to kid you, Ted. The Cole case was a slam dunk, although it looks like you did rather well on the judge draw. Eastern District of California. I don't think I think too much about the Eastern District of California.
Well, it's where Sacramento is. So it was just easy. We didn't want to have a fight over, suing in the Central District and having it get transferred to the Eastern District.
No, I mean, I think I have ended up there myself, but you're always thinking northern, southern for LA, and and in any event, what is it that you got? Like, is there a way that you distinguish yourselves from what the other guys are doing? We're just hey, this is us. This is what we do. We have this specialty in the class action fairness stuff, but we're looking for this kind of stuff.
We're looking for First Amendment stuff. We're looking for, I think we sort of have a big law mentality. We're a lot of big law refugees. And I like that we're nimble. I like that we don't have a bureaucracy. We've considered merging with some other or joining some other conservative public interest law firms. And we learned that, well, they only initiate litigation after a quarterly board meeting. And we don't need to do that. We decide we want to sue. Let's do it. And we within a week of the Gavin Newsom tweet, we had signed up a client, and we started researching and drafting the complaint, and we were ready to go.
You signed up the client. You had signed up the one guy who you knew would not suffer from.
We signed up the one guy we knew would have standing. That we won this amazing case in Pennsylvania over Pennsylvania ethics rule 8.4G, which basically banned right-wing speech.
Which one was that?
I'm sorry.
What was the name of the case?
It was Greenberg, and lots of different defendants because the guy kept changing. But we won a permanent injunction in the district court, and then on appeal, Pennsylvania pretended, oh, we're never going to prosecute this guy. Well, you waited until the middle of the litigation to tell us that. How does that deprive us of standing? But the Third Circuit, I think incorrectly, held that did deprive us of standing, and our injunction got thrown out. In the process, Pennsylvania, we argued against Lisa Blatt, who's, one of the three best Supreme Court advocates, appellate advocates out there. And
I know her well.
She she argued very effectively, but to do that, she basically narrowed the law next to nothing, which, if Pennsylvania had done that on day one, there wouldn't have been a lawsuit. But they waited until the Third Circuit to just basically say the law doesn't apply to anything. So in some sense, it was a victory. In a more official sense, it was a loss because we got thrown out on standing and we don't have an injunction and we don't get attorney's fees. But
it is amazing, though, isn't it? I did quite a few cases during COVID on a number of grounds, and states would keep changing their rules. Like since we lapsed for several years into a dictatorship, it was no longer necessary to pass legislation or do any rulemaking. So every time you'd go into court, based on how the previous oral argument went, the state would say, "Oh no, we took that part out for now."
Yeah.
And judges would freaking buy it. And I mean, that's basic constitutional law. It was I think the cowardice of the judiciary during COVID was one of the most distressing things I've seen in the legal profession since I've been involved.
I think there were some unfortunate rulings in both directions there.
In both directions.
But there was some silly District Court of Texas rulings on one of the airlines. But
yeah, you're right. You're right.
I do think the standing doctrine has gone too far against rectifying rights, that it's too easy for government to play hide the ball, too easy for government to bait and switch. And, if government can snap its fingers and say, oh, the law doesn't apply to X anymore, well, they can go flip it the next day after the case is over. And the standing doctrine is supposed to cover that, but courts are just excited to throw these things out and not rule.
What do you think is going to be the challenge? Let's go crazy and imagine that Donald Trump wins the next election, becomes president. There's going to be a lot of litigation, I assume, don't you? Challenging every little thing he does.
The District of Hawaii will become very powerful again until the Supreme Court steps up and says, these nationwide injunctions don't play anymore, which, they're sort of leaning towards, but hasn't happened yet.
So that actually might be that's a good point. This could serve up in the coming year or two with one of those moments where they finally stop hinting about nationwide injunctions and do something about it.
So that I think whoever is president, that gets resolved in the next 4 years. There was always a bit of a double standard when it came to Trump. I think the Department of Commerce case, where they were basically allowed to sort of investigate the purity of the motives for making a decision, the sort of thing the courts never used to tolerate.
I was astonished. I was astonished. I remember the Supreme Court argument that they were actually talking about what he said in a campaign commercial.
Right.
There's no end to it once you start that. It's just unbelievable. And yet it's not. We see it, we're living it.
And there's something to that. And I think standing becomes malleable in a way that it hasn't been. We need a more consistent standing doctrine. That just needs to be fixed. And
do you have any other?
There are a lot of things but
do you have any other favorite? I heard a very good talk by Josh Blackman last week about potential court reform ideas. And first he went through someone else's list and trashed it, as you would expect in one of these talks, and then gave his very creative ideas, being Josh Blackman. Anything that you ever, fall asleep with a little smile thinking, if I could impose one or two things on the judicial code, here's how I would tinker with it.
I would make Supreme Court justices divest their individual stock holdings.
Yeah, that was one of his also. Buy an index fund. You're no better than anyone else. You don't need that.
Right. You already have a life tenure. You already have a life pension worth millions of dollars. You don't have to have Procter and Gamble stock. Invest in an index fund.
But do you think any Supreme Court justice has ever been motivated by stock holdings to rule one way or another on a case?
No, but they recuse, and once that happens, cert doesn't get granted. Justice Alito owns Procter and Gamble stock. We appealed a Procter and Gamble case. He recused, and now there are 8 justices. So now it's not a great vehicle because it might go 4-4.
A great point.
It's very funny when everybody says, "Oh, Clarence Thomas should have recused on such and such a case," where there is this really, really remote non-requirement for him to recuse. But the thing that Harlan Crow had like a tertiary interest in, he was the respondent, and if Thomas had recused, you still need 4 votes to grant cert, but now you're not getting one from Thomas, and now the court isn't even going to take it off of the calendar.
How about this? How about these book advance scams?
Yeah, I can see there's some problems there, and I think it's not just book advances, but Sotomayor gets a lot of free publicity for her books that other justices don't get for their books. Right. She'll get millions of dollars of free publicity from the left-wing media. Gorsuch won't get those for his books, or Thomas for his books. And so her books sell more.
Oh, well, just another scam you and I are missing out on.
Yeah.
Well, Ted, at least now, because of social media, we are media stars in addition to being underpaid.
For sufficiently broad definition of stars.
Internet niche famous. Very good catching up with you, and you're doing great stuff. It's very exciting. The work you're doing with Hamilton, Lincoln, and I hope you keep doing it and that we are able to stay in touch. And
Absolutely. So we are at hlli.org.
Yeah,
we are a nonprofit, and we depend very much on our generous donors. We have a shoestring budget, and a little money goes a long way with us.
You can donate, folks. Donate. Hill.org, donate. I'm all in favor of your donating because these guys do important work, and this is how it works. Lawfare has become a little bit of a two-way street, and not both sides play by the same rules, but we do it our way. We do it, I think, the right way. And frequently we do it Ted's way, and it works.
Thank you, sir.
Ted, great seeing you again, and I hope that you continue.
Great seeing you. Give my best to everybody at the firm.
By all means, I certainly will, and continue your recovery, and I hope to see you at full strength in the near future.
Wonderful.